Good morning, everybody. Uh, Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to said executive session or at the next public meeting thereafter. Executive meetings were held on December 6, 2016, January 24th, 2017, January 25th, 2017, February 15th, 2017, and March 28th, 2017, to review matters. They are by statute confidential, including completed investigations for the purpose of issuing final adjudications, motions in investigative matters, applications for 90-day extensions of investigations filed by the investigative division, terminating certain preliminary inquiries as recommended by the investigative division, and discuss administrative matters. With that being said, I'd like to make the opening statement concerning our public meeting. Pursuant to the Public Official and Employees Act 170 of 1978, as amended by Act 9 of 1989 of June 26, 1989, and as amended by Act 93 of 1998. The State Ethics Commission is specifically mandated to hold at least 2 public hearings each year, each of which at least one shall be held in Harrisburg and at least one shall be held in a location other than Harrisburg, to specifically seek input from persons and organizations who represent any individual subject to the provisions of this act and from other interested parties. We have placed on the agenda for today's public meeting a notice that the Commission will be meeting today in part to receive the input or testimony of said individuals pursuant to the provisions of the law. As our previously published notices indicate, the Commission will request copies of any statement that is presented. The individuals presenting statements before the Commission will be allocated 15 minutes in order to complete their statements. Statements shall be uninterrupted, except that such statements may be interrupted or terminated by the presiding officer if it is determined that the statement is impertinent, scandalous, or otherwise improper. So with that, minutes of the March 29th, I'm sorry, not March 29th, the January 25th meeting. Have approval of the minutes. So Mark Corrigan approves, and Melanie DePalma seconds.
Yes, second.
Okay, the first matter is the Manolis opinion.
Oh, you have to vote.
Sorry, we didn't vote, that's right. All those in favor signify by saying aye.
Aye.
Nay.
Aye.
Nay, the ayes have it. Okay, it's amazing, I mean, it's all jump on you.
Just wait.
Man, first, item 2, the Manolis matter, Mark.
Yes, the Manolis, the facts pertaining to this advisory request are as follows, Mr. Chairman. The requester is James W. Manolis, legal counsel of the Lawrence County Economic Development Corporation, which I shall refer to as the LCEDC. Mr. Manolis has been authorized to request an advisory from this commission on behalf of the Board of Directors of the LCEDC, Mr. Sam B. Biasucci, who is a member of the LCEDC, and Linda D. Nitsch, who is an employee of the LCEDC. Mr. Manolis seeks a determination as to whether the members of the LCEDC board, Mr. Biasucci in his capacity as a member of the LCEDC, Ms. Nitsch in her capacity as an employee of the LCEDC, and Mr. Manolis himself as legal counsel of the LCEDC would be required to file statements of financial interests with this commission pursuant to the Ethics Act. Mr. Manolis has submitted extensive facts and documents which all of the commissioners have received. I shall not attempt to outline the contents of the LCEDC bylaws and other documents that we have received. Stated succinctly, the LCEDC is a nonprofit corporation that was privately created without the involvement of a political subdivision or other governmental entity. However, the LCEDC performs some governmental functions involving government grants and loans. Mr. Chairman, I would suggest that this would be an appropriate time for any interested parties to speak on this matter. I don't think there are any here. No. Would any of the commissioners like to go into recess for quasi-judicial deliberations? Seeing none, now proceed with your leave, Mr. Chairman. I have reviewed the facts and the relevant statutory provision. It is my view that none of the individuals about whom Mr. Manolis has inquired would be public officials or public employees subject to the Ethics Act, and therefore they would not be required to file statements of financial interest pursuant to the Ethics Act. My view is based upon a literal application of the relevant definitions, as well as the fact that the LCEDC board members should not be treated differently based upon how they get on the board. To do so would be an absurd and unreasonable interpretation contrary to the rules of statutory construction. Based upon this analysis and comments, I move that the holding of this commission in this matter be as follows. Based upon the submitted facts, members of the Board of Directors of the LCEDC, Sam B. Biasucci, in his capacity as a member of the LCEDC, and Linda Nitsch, in her capacity as an employee of the LCEDC, are not considered public employees or public officials subject to the Ethics Act, and therefore they are not required to file statements of financial interest pursuant to the Ethics Act. Additionally, based upon the submitted facts, Mr. Manolis, as legal counsel for the LCEDC, is not required to file statements of financial interest pursuant to the Ethics Act.
Second.
Motion made by Mr. Corrigan, seconded by Mrs. Healy. Any questions? All those in favor signify by saying aye.
Aye.
Nay.
Aye.
The ayes have it. The next matter, skipping around to Mosky, Ms. Mosky by Roger Nick, the medical marijuana act.
Thank you, Mr. Chairman. The facts pertaining to this request are as follows. The subject of this request is Karen C. Mosky. Ms. Mosky serves as the executive director of a nonprofit hospice provider named Hospice of Metropolitan Erie Incorporated, which I shall refer to as Hospice of Metropolitan Erie. In 2015, Hospice of Metropolitan Erie created a for-profit entity named Northwest Project for Wellness to generate funds to support the charitable work of the nonprofit. Northwest Project for Wellness plans to apply for a medical marijuana dispensary license. The operations of Hospice of Metropolitan Area and Northwest Project for Wellness will be kept separate with different accountants and board members, but Hospice of Metropolitan Erie plans to provide a loan from its reserves to Northwest Project for Wellness to launch the startup of the dispensary. Ms. Mosky is a paid employee of Hospice of Metropolitan Erie, and she has also been identified as an unpaid operations manager for the Northwest Project for Wellness. Additionally, she is an elected member of the Executive Committee of the Pennsylvania Democratic Party. In her request letter, Ms. Mosky requested an advisory opinion from this commission regarding her activities as they may relate to the Medical Marijuana Act. She was informed by letter of the Chief Counsel dated February 3rd, 2017, that the commission has statutory authority to issue determinations, but not advisory opinions under the Medical Marijuana Act. Specifically, our jurisdiction is limited to addressing whether Ms. Mosky will be subject to the restrictions of sections 2101.1 A and B of the Medical Marijuana Act. Mr. Chairman, I would suggest that this would be an appropriate time for any interested parties to speak on this matter. Okay. I've reviewed the facts and the relevant statutory provisions. the restrictions of section 2101.1 A and B of the Medical Marijuana Act apply to party officers. The Medical Marijuana Act defines the term party officer as it is defined in section 1512B of the Pennsylvania Racehorse Development and Gaming Act, and that definition includes a member of the executive committee of a state committee. Ms. Mosky falls squarely within that definition. Based upon my analysis and comments, I move that the holding of this commission in this matter be as follows. Based upon submitted facts, Ms. Mosky's service as an elected member of the executive committee of the Pennsylvania Democratic Party would bring her within the definition of the term party officer as set forth in section 1512B of the Pennsylvania Racehorse Development and Gaming Act, and therefore Ms. Mosky would be subject to the restrictions of section 21.1 A and B of the Medical Marijuana Act.
Okay,
Second.
motion by, Roger Nick, seconded by Mark Corrigan. Any questions? All those in favor signify by saying aye.
Aye.
Aye. Ayes have it.
Aye.
The, next matter is the, civil penalty orders consents. Melanie?
Yes. Okay, there are two civil penalty cases with proposed consent agreements that are now before this commission for decision. These cases involve respondents James Knox and Robert Geegan. Respondent Knox failed to timely file a statement of financial interest for calendar year 2015. Respondent Geegan failed to timely file statements of financial interest for calendar years 2013, 2014, and 2015. The parties have submitted consent agreements proposing that the commission find that the respective respondent failed to timely file one or more statements of financial interest and impose one or more penalties. Respondent Knox has paid the recommended civil penalty in his case, but has not filed the delinquent form. Respondent Geegan has both paid the recommended civil penalties in his case and filed the delinquent forms. Based upon my review of the facts, I'm of the opinion that these consent agreements are consistent with commission precedent and are proper dispositions for these cases. It is my opinion that the commission should order Respondent Knox to file his delinquent statement of financial interest for calendar year 2015. There is nothing of record that would constitute a defense or excuse for his noncompliance. Based upon my analysis and comments, I'd like to make the following motion. I move that this commission approve the consent agreements submitted by each of the following respondents and the investigative division impose civil penalties for failure to file timely statements of financial interest as follows. First, James Knox, $150 for calendar year 2015, and secondly, Robert Geegan, $300 for calendar years 2013, 2014, and 2015. I further move that Respondent Knox shall be ordered to file his statement of financial interest for calendar year 2015 within 30 days of issuance of the commission's order. Mr. Chairman, that is my motion.
A motion by Mrs. DePalma, seconded by Mr. Nick.
Question, Mr. Chairman.
Question.
Is there a reason, is it just negotiations because Geegan's is only $300 instead of $450?
Yes, we've given some consideration to those individuals that are willing to file and negotiate a settlement rather than go into default.
Very cooperative.
Yes.
So the only aggravating circumstance is 3 years in a row.
3 years, yes. You know, we took that into consideration, but if we did negotiate something and that he didn't file, and we went into Commonwealth Court, the court recently has been questioning whether we could get costs. In fact, we had to file a brief with the Commonwealth Court. They're saying, Brian could probably say it a little bit better than I can, that Judge Brobson in Commonwealth Court initially denied a request to collect costs. So we, rather than being out close to $100 in costs, if we can negotiate a little bit lesser penalty with some of these people and they're complying, it's an easier way for us to get rid of it.
What's the Commonwealth Court's reasoning?
because this is a public meeting and that deals with settlements, negotiations, and settlement aspects, it may be something that I would prefer to be discussed in the executive
So
session.
I don't mean, I meant the why Commonwealth Court.
The reasoning behind the Commonwealth Courts is that the enforcement of administrative penalties falls in its own category, either appellate jurisdiction, it follows the rules of appellate jurisdiction as opposed to the rules of civil proceeding appeals. And what is happening is Judge Brobson believes that service fees, the fees that we have paid to sheriffs to get something served, is a non-taxable fee, meaning we cannot seek that as a reimbursement of cost. With that being said, we spend an awful lot of money in sheriff's fees to have people served,
Yeah.
and it makes better judicial sense of for the fiduciary duty of the public's money to negotiate a settlement as opposed to spending additional costs to collect a small amount.
I think it is too, and I agree with you. I might suggest that we add that to a list of possible amendments to the act to present to the legislature if and when anything moves across the street, because I mean, it's ridiculous that the penalty is $150 for Commonwealth Court. Won't give us costs, so it's ridiculous to even lower the penalties yet. So maybe we should add it to that to the list of amendments to the act.
We haven't voted on this matter, so all those in favor, signify by saying aye. Nay.
Aye.
The ayes have it. Okay, item 5, civil pending order defaults, Melanie?
Yes. There are 7 civil penalty default cases that are now before this commission for decision. The respondents involved in these cases will be identified individually in the motion I will be making with regard to these cases. These respondents failed to file 1 or more statements of financial interest for the calendar years that I will detail in my motion. These respondents did not take action or respond to the civil penalty proceedings. Following review, it is my opinion that as to each of these respondents, the Commission should levy a maximum civil penalty of $250 for each delinquent statement of financial interest. It is my opinion that the Commission should also order these respondents to file their delinquent statements of financial interest, as there is nothing of record that would constitute a defense or excuse for their noncompliance. Based upon my analysis and comments, I would like to make the following motion. I move that this commission levy maximum civil penalties against the respondents in these 7 civil penalty default cases as follows. For the following 5 respondents, I move that this commission levy a maximum civil penalty in the total amount of $250 against each respondent for failing to file a statement of financial interest for the respective calendar year. Heather Mitchell, calendar year 2013. Yulissa Espinal, calendar year 2014. Barbara Cortez, calendar year 2015. Chad Schroy, calendar year 2015. And Jeanette Marcus, calendar year 2015. For the 6th respondent, Michael Savulak, I move that this commission levy 2 maximum civil penalties in the total amount of $500 against respondent Savulak for failing to file statements of financial interest for calendar years 2013 and 2015. For the final respondent, Justin Craddy, I move that this commission levy 3 maximum civil penalties in the total amount of $750 against respondent Craddy for failing to file statements of financial interest for calendar years 2012, 2013, and 2014. Further, these respondents shall be ordered to file their statements of financial interest for the years stated within 30 days of issuance of the Commission's orders. Mr. Chairman, that is my motion.
Second.
Second by Maria Shealy. Any questions? All those in favor, signify by saying aye. Aye. Nay.
Aye.
Ayes have it. Now getting into the alternate area, Mr. Corrigan.
There are 2 administrative penalty cases with proposed consent agreements for our consideration. The following respondents are principals who failed to timely file a quarterly expense report for the 2nd quarter of 2016. Penn Environment and Affiliates, and Working Families Organization. In each case, the parties are in agreement that the respondent's transgression of the lobbying disclosure law was negligent. Both respondents have now submitted their delinquent expense reports to the Department of State, but have not yet paid their agreed upon administrative penalties in the amount of $1,960 each, or their additional cost reimbursements to this commission in the amount of $250 each. Mr. Chairman, I would suggest this is an appropriate time if any interested parties would like to speak on this matter. See any? Mr. Chairman, I have reviewed the facts of these cases. I am of the opinion that the consent agreements are proper dispositions for the respective cases. I would like to make the following motion. I move that this commission approve the consent agreements submitted by the investigative division and the following respondents, and impose the following administrative penalties. As to Penn Environment and affiliates and Working Families Organization, 1 administrative penalty each in the amount of $1,960 for their delinquent expense reports for the second quarter of 2016. I further move that Penn Environment and affiliates and Working Families Organization are directed to pay the agreed upon additional $250 payments to be made to this commission, representing a portion of the costs incurred by the commission in the investigation and enforcement of the respective matters. Penn Environment and affiliates and Working Families Organization are directed to pay their administrative penalties and the aforesaid additional payments of $250 each within 30 days of the mailing date of this commission's order.
Motion by Mr. Corrigan, second. Roger Nick. Any questions? All those in favor signify by saying aye.
Aye.
Nay?
Aye.
The ayes have it.
Mr. Chairman, just, those penalties were a little bit less than what we've recommended in the past. And part of the reason for that is the two entities had tried to file online with the Department of State, and their process over there is not the greatest. They could show that they tried to file, they had conversations with the Department of State, couldn't get it worked out, and then they were remiss in then not getting back or filing a paper form. They got frustrated. So we gave them some leeway when we negotiated the settlement here, but there has been legislation that passed in the Senate to require all filings to be made online, because the Department of State now you can file either paper form or file online, and it's a problem for us in even getting certifications of when the principals and the lobbyists are filing. So we're hoping that the bill will pass in the House as well, so that they're trying to be a little more uniform filing procedure for everyone. It would help all those who are required to file, would also help us in our enforcement efforts. Yeah, it's usually we negotiate 35 or so we went a little bit less, give them some consideration for some effort to try to file.
Okay. Public comment. Is there anyone here would like to say something? With that,
Mr. Chairman, could I make one short comment? I'd just like to know for the record that it seems like we have a relatively short agenda today, but we did have 2 additional matters on the agenda that were withdrawn at the request of the individuals. So I just to clarify a little bit, our agenda is shorter than we expected.
Yes.
were you going to say just about the same thing?
Yeah. And then they were controversial, more controversial matters.
Can I have a motion? We did adjourn. No, we didn't adjourn. Ray makes a motion to adjourn. Seconded by Roger Nick. All those in favor signify by saying aye.
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 The ayes have it.